Well, I want to welcome everyone tonight. We have a pretty packed full presentation. So I'm going to pull up the presentation. This webinar tonight is about how can you ask the courts or demand the court protect your child's rights and your rights. And most of you might be in a divorce. Some of you might be in child custody battles or paternity or even in juvenile court. So we're going to go over who these rights apply to, what these materials do for you, and we'll show you an overview in a minute. So let's get started. This is I'm Getting Divorced and I Don't Know What to Do. This is being presented by fixedfamilycourts.com. And this is a video that some of you might have seen that we produced to show what some people are going through when their divorce is first filed. So who are your presenters tonight? Well, that would be myself, Sherry Palmer, and Ron Palmer. He's sitting here with me. I don't know if you guys saw him, but he's right there. So, well, a little bit about us is we're a husband and wife team. We're highly respected authors, speakers, and business professionals. Probably can't tell the way I'm speaking on the webinar tonight. I get a little nervous when the technology is challenging to me. We are authors of a couple of books in the family court arena, and then you probably don't know about Ron's other book that he wrote in, it's a different business arena. It's technology management. So Ron's first book in business and technology management, which I edited, has been used as a university textbook all over the world. And it was the basis for a graduate program at the University of Dallas, where Ron served on the board for that master's program. Ron has presented at multiple academic conferences. So while we play ourselves down in the family court arena, we are highly respected professionals who are well known for our innovative and creative ideas for identifying and solving intractable problems. So why is that important to you guys? Because you might wonder, how the heck does Ron and Sherry come up with all of this novel material, and why hasn't this ever come about before? Well, that's because they probably didn't have the combination of our backgrounds and our brains. So unfortunately, there's some things we'll go over tonight that have prevented most people in the family law field, most of them the licensed attorneys, judges, and other peoples. We are not attorneys. We are not practicing law. We are not licensed to practice law, nor have we gone to any law school. So what that means is we have different backgrounds that has allowed us to break through the biases. And with Ron's background, I believe he described it as, would you say it's like process?
Yeah, so what I'm classically trained as an economist, and the first thing economists are always taught is question all of your assumptions. So that was a vital skill in breaking through all of this. And there's one thing about challenging your assumptions and challenging the status quo. If your income depends on the status quo staying the same way it is, you're never going to think through the ideas to break it down. Your brain just will not do it. These attorneys, these judges, all have their livelihoods dependent on the family law system working the way it is today. If they were to follow the Constitution, most of the money would leave the system. They would have to find other ways to earn a living, not in their personal financial best interest to solve this problem.
So back to the background, you are experiencing like process mapping and...
Right, I work in some of the largest companies in the world, Fortune 5, all the way up to the Fortune 5. I help them structure very large, global, complex business environments where they manage multiple billions of dollars worth of technology. I teach them how to manage that, structure it, weed out the complexity, simplify work.
So that's what we're doing for you in these webinars. And this is going to understanding how and why and what these materials do for you. And so let's go on to our introduction. So I've also, Sherry, myself, I've helped numerous parents by working with the parents and their attorneys. I've attended trials with them. I've prepared the parents for testifying, help them even create the questions that they'll ask other witnesses, help them organize and prepare evidence and their entire presentation for the attorney as well, and framing for the court. I also use my public policy degree to help people work on proposed legislation and present it in a way that legislators are familiar with. And that's also important with our materials for the judges and the attorneys. We use language that the judges and attorneys are familiar with. So Ron and Sherry both have created the content that you see here ourselves on the website and published elsewhere. We have blogs, we do these webinars, we appear on radio shows and different things like that. So we've created all of the arguments and the content that we use. We also have provided specific constitutional language that has helped the movement be much more impactful and effective. When we're talking about the parental equality movement, the equal parental rights, shared parenting, father's rights movement, all of the organizations that strive to stop the biases in the family courts, our materials have provided more impactful and effective argument for them. So when we first came into this arena about 2013, that was after all of our court hearings, we published our book in May 2013. The movement was experiencing a lull, like it was kind of stagnant. And when I did my first webinar, people were complaining, what's going on? I think the movement's dying. It's just not working. And they were getting really, really frustrated. So we did a few webinars on that. And once we started getting the word out to more people, we noticed more people were starting to adopt the language. And now what has happened is we've seen another shift. We know now that this movement might have hit a tipping point because the language that others are using is now mirroring the arguments that we have in the book and that we've published in other places and from the webinars.
So what's happened is when we first got involved with all of this, most people were basically begging their legislators to treat them better, be nicer to me, give me something, right? And what we've done, and not just us, but in large part us, is we've crafted language that says we're not asking you to give us anything. We're telling you that we have fundamental constitutional rights. The federal courts have been very clear that we have these federal rights. What you're doing is stealing these rights from us. What you're doing is stealing these rights from our children, and we want you to stop. And we demand that you follow the Constitution. That's a much different argument than begging a legislator to be nice to me, to give me something. We don't want them to give us anything. We want them to stop taking from us.
And with that, we're going to proceed with the presentation. So what will we cover tonight? We're going to cover the divorce bias. Who should use these motions? What do these motions do for you? Understanding the declaratory judgment. And by the way, I wanted to let everyone know, no, we have not received word or ruling on that yet, because I did receive several emails that I haven't had time to answer, so I apologize. But we're going to help you understand the declaratory judgment for the state level, like what you can do at the state level, because we filed in federal court. And what else we're going to cover? Equal protection and due process motions. Those are new breakthrough motions that many of you might have seen on our website. The due process motion is protecting your substantive rights. We're also going to cover the importance of procedure, objections that you will encounter or may encounter when you're trying to use these motions, and then our closing. So first we're going to cover some divorce bias and why you are even having to ask the court to protect your child and your fundamental rights. Well, if you're not very far in this process, you may not have experienced some of this yet, but I have an inkling that most of you probably are experiencing what doesn't feel right to you, and it's what we describe as corruption, collusion, abuse of power, bias against divorcing parents or parents whose relationships didn't work out, and we'll explain more about that later. Extortion, I don't know any other word for it, but when they're stealing your money, imposing extra debts on you to pay for extra things just to protect your rights that were already yours before you entered that court, You know, I'm not saying that we're describing what meets a legal criteria, but I'm saying what is happening to you, okay? Bankruptcy. A lot of parents who go through this experience bankruptcy. So how do you protect yourself from these harmful practices? Well, you're going to hear about that through the rest of this presentation. And we have a cute little cartoon there. You guys want to look at that. That's not our cartoon. That's baloocartoons.com. They have a bunch of cute cartoons on there. You may want to visit there sometime if you just need a comedy break. Although this isn't that funny. This is pretty serious and harmful. Who should use these motions? Everyone who has children. Every single person who...
What motions?
Oh, sorry. Oh, okay. I think I moved some. Oh, no. I put that word there, even though we haven't covered them yet.
Okay, so we're going to cover some motions that we provide.
Oh, I have that right here.
Okay.
So I mentioned, so if you guys are not familiar with the motions, don't worry about it. We'll tell you the page to go to look at those. Actually, you can go to www.fixedfamilycourts.com/motions, and there will be a link that you can click on there, and it'll take you to the page about the motions. Okay.
So real quickly, what these motions are, they are training materials that are written in the form of a motion so that you understand how this is done, so that it helps you present some of these rights issues to the court.
Okay, but we'll go over a little more detail on those in a little bit. But let me tell you why you should use them first, so you understand how important these are. Most people, when they go through divorce, the first thing that happens is you'll go to an attorney if you're served with a divorce lawsuit, and that attorney will tell you that you need to file a counter pleading or a response pleading to the other side, and they won't mention a thing about your rights, and they will file motions that only essentially beg the court to pick you to have the majority of the rights over the other person, and that puts you in a very bad cycle. So what do these motions do for you?
Well, first, we've actually seen motions where the attorneys put in the motion that they're asking the court to make a best interest determination. Just simply by saying that, what the attorney is saying is that my client waives all of their fundamental rights, and they want to jump right over that and let you have all the power and you make the decision. Those kinds of things we cut out, and these motions are designed to cut that out. Now, you also need to work through with your attorney and make sure they're not saying those kinds of things in your pleading.
And if they don't have it in your pleadings, they are saying it in the oral testimony when they have a hearing. They're saying, hey, judge, these two parents don't get along, so yeah, we're here today to let you decide which parent gets what rights, okay? Or they'll say, I want you to decide the best interest of the child directly. But even if they don't say it and they just say, we're here today because the parents don't get along, they're basically indicating to the court that they want the judge to make a best interest determination. So these motions will address that and tell the court that's not what you're asking them to do.
And most importantly, it puts it in the record in writing that you are asserting all of your constitutional rights and you're not waiving them.
So these motions, by doing that, place limitations on the judge's discretion. So you're not placing those limitations on their discretion. We're not doing that either. We wrote these motions in language that reflects the Supreme Court language and appellate court language. So the Supreme Court has decided that the Constitution limits the judge's discretion when they're addressing fundamental rights, which is what parental rights and your child's rights to be protected by you are. So these motions also prevent the court from adding unnecessary burdens. Those would be custody vows, psych evals, unnecessary discovery, and it prevents GALs, guardian ad litem, amicus. I learned that they call those CFIs, I believe, in Colorado. There are a lot of different labels they put on these, but these are unnecessary burdens, and That's because of some of the things that we state in the motions. Some of your fundamental rights protections require some other steps before they're allowed to place these unnecessary burdens on you. They also the motions prevent the court from dragging out the process. So when they impose unnecessary burdens on you, like custody vows, psych evals, social studies, what happens? Those take a lot of time before they get done, right? Sometimes months for these people to go through their process, create their reports, and submit it to the court. And what's happening to you if you're on the back end of these orders? If you're the one that was ordered to pay child support, you're the one that was ordered that you could only have visitation because you've already been through maybe a temporary orders hearing, what's happening to you? You might not be getting to see your children. You might be going into such serious debt over the cost of all of these burdens that they've placed on you that by the time you get back into court, you're going to find yourself, instead of just fighting to protect and save those rights, you're going to find yourself fighting to stay out of jail. So these motions are designed to help protect you from getting into that position. These also protect you from those third-party opinions. So when the gals and others try to come in and say they know what's best for your child, that's all in there too. It prevents the abuse of power by the courts, the attorneys, or anyone else that's trying to cheat you out of these rights and cheat your children out of these rights. And as we said before, it prevents unnecessary discovery. Those custody vows, psych vows, things like that, that's discovery, but we're also talking about these really expensive depositions and, you know, all kinds of things that they put you through, answering a whole slew of questions that invade your privacy. But it costs money, doesn't it? It's costing you hours to pay those attorneys to sit there and go through that material and produce it and all the stuff that they need to do. So what else do these motions do for you? They also protect you from inflammatory judgments and long trials of ridiculous complaints. So let's say you've been through the process. So we're addressing everybody here, people at the beginning, people in the middle. Now these will be the people at the end where you're facing a trial. You might be facing a whole week-long trial now because you've had so much discovery that has taken place throughout the course of this divorce or child custody battle that now you need a really long trial so they can enter all of the inflammatory stuff that they dug up, right? Opinion or that they developed throughout the course of this whole process. So it's ridiculous complaints, like what this cartoon says. Oh my gosh, she hid my, there's one cartoon that says, you know, she hid the remote to the TV, and this one says he recorded over her soap operas. That stuff, I believe, actually does happen. I haven't heard those specific ones, but I've heard people complain about so-and-so leaves the gate open, they're irresponsible. It's just things that you think that the judge would know better than to even allow them to spend time on. But anyways, they don't because they're making money. So what else do these motions do for you? They protect your children and you, by the way, from parental alienation. Now, so I guess I technically wrote that wrong. They protect your children from being involved in alienation, and they protect you from parental alienation. We call the process itself an alienating process, and you'll learn about that in a little bit. But this is also another video that we made. We just don't have time to go over them. Again, if you want to see the videos, they're on our YouTube channel. Everybody registered, they will get an email from us with the link to this video and the links to our motion pages, to these videos, and anything else that I think will contribute to the material that we covered in this webinar tonight. So how else can these motions protect you from being alienated? As I stated a few minutes ago, the courts become alienators themselves when they make you a second-class parent and restrict your time and authority with your child. We call this court-induced parental alienation. And that's because the alienation would not have been able to be so effective if the court had not created an imbalance of power. So they put the other side in control over your rights. And there's another reason that you want these fundamental rights protected is when you lose these fundamental rights, you become powerless. It has driven parents into a cycle of hopelessness and depression. And as you all have seen in media time and time again, too many times, parents hurting themselves or others, they are devastated. They do not know what else to do. I've even seen parents who have alienated, and I'm not going to mention names because there's some that are very prominent in society, and some of them even, you know, try to fight against parental alienation, but they themselves were alienators. Sometimes I don't know if they realize, you know, they got hurt in the process, but I don't think they realized, they didn't know what else to do, some of them.
And so this concept is very important, and it's so important we've actually trademarked this term, court-induced parental alienation, because most of the parental alienation that takes place can only happen to the degree it does because of what the court does. Right? In most cases, if your rights were protected equally and you have equal time with your child, even though the other side is working against you, they cannot take your time. The child cannot be threatened to be taken away from you or be kept from the other parent. Both of you are going to have your time. You have opportunity to counter anything that other parent does, right? And there is certainty for everybody involved that the rights are going to be protected, and none of this bickering and fighting and made up stuff is going to do anything to hurt your rights, because the bar to take those rights away is very high.
And we covered earlier that fishing expeditions, these motions restrict courts fishing expeditions, that's discovery. That's when they're having others question you, even mental health discovery, things like that. If they have not proven proper grounds for that, which we would say Fourth Amendment, if they have not proved.
Essentially, if they haven't established the constitutional authority to infringe your parental rights, if they haven't found you previously to be unfit, and they can't prove a specific and meaningful harm to the child.
That's something you did directly to the child.
Speaking in terms of charges that are written down and properly served on you so that you can respond to specific written charges. If they haven't proven something of that nature, then they have no business and no justification for conducting any kind of discovery regarding your parenting ability, any of these things. Because your parent, you don't have to be a model parent to keep your equal time with your children. The Supreme Court has said it in those words, right? So, and
that's even when they're saying, oh, we need to ask you about what kind of home you're raising your child in and compare it to the other home the other parents raising their child in. That's baloney. That's none of their business. You weren't being questioned before you walked into the court when you guys were together what kind of home you provided for the child. And by the way, that's a violation of your fundamental right to raise that child how you see fit. If you want to raise that child off the grid, that's your option. But what's going to happen if you're in a custody battle? They're going to judge you. If that other parent has a bunch of money and a nice 3-bedroom home in a, you know, perfect little neighborhood, they're going to judge you, and they're going to use a bias against your poverty, basically. I mean, that's maybe a choice, but they may see it as poverty. And that's something that we express in these motions as well, is that the court is not allowed to punish you for poverty, but they do it all the time. And that's how they hide it, with these biases of saying, oh, but I'm just looking out to protect the child. We're saying those are not things that they are authorized to protect the child from.
So what you learn in our book and our materials is that the basic premise of equal protection is that they cannot do it to a married couple. They cannot do it to you simply because you're divorced or because you're a single parent, right? In almost every situation, that is the case. Marital status cannot be used against you, period. And that means divorce cannot be used against you. And they're doing it anyway. We realize this, but they're doing it because these attorneys are not challenging it properly. And part of what we're doing is helping you understand how to challenge it properly.
And on the slide we're on now, which is how can these motions protect your relationships? These motions also prevent you from needing to drag a bunch of friends into your divorce. As you can see this little cartoon here, since the divorce went well, but I got 60% of his Facebook friends. You know, some people who haven't been through it might think, oh my gosh, that's so ridiculous, but it's true, isn't it? You lose a lot of friends going through this process. And lot of it too is they just don't like the pressure. They don't like being dragged into the middle either when they're asked to support one of you over the other. And so many times the courts require you to bring in people who support that you're the better parent. These motions cut that off as well. They are telling these courts that is an invasion of your privacy. The divorce bias culture, however, is changing, and some of you might have seen a post that we made today on our Fixed Family Courts page where the Catholic Church endorses shared parenting. It was about 2014 where they originally started speaking out publicly, and we got this article. It was on Cordell and Cordell from Dad's Divorce, and NPO wrote a lot of the content, which is National Parents Organization, wrote a lot of this content that dadsdivorce.com, Cordell and Cordell got this information from. But November 2014, he said children have the right to be raised by a mother and a father. Well, one, coming from the Catholic Church, that's amazing because you know what their stance has been on divorce. They kicked divorced people out of their court. Out of their church, excuse me. So, and then I guess just last year, the Pope started speaking up a little more and more, demonstrating that they are working through their biases and favoring shared parenting.
Right. So this new Pope is very much against punishing people, and he's very much in favor of accepting people and helping people work through issues. Right. Well, one of the things we have to realize is that the legal system, for its entire history, has been punishing divorce. The marriage started out as a legal and religious concept. It was framed up in the religious laws in England that we inherited. And even though we no longer have religious laws per se, we have many laws that are based on religion. And most family codes are based on religious concepts. They used to be based on the idea that your parental rights depended on your marriage. If you had a child outside of marriage, that child was an illegitimate child, could not inherit from you, could not take your name, didn't have the same rights as other children. And oftentimes the parent didn't have rights to the child. Usually the father didn't have rights to the child, the mother would. And sometimes the state would take the child from both the mother and the father because they made your parental rights dependent on the marriage. Well, in the early 1970s, through a series of cases, the Supreme Court said that is absolutely ludicrous. You cannot do it. It violates the fundamental rights of the parents. It violates the fundamental rights of the child. You cannot punish the child for the sins of the parents, is the basic statement that the Supreme Court has made.
Right. And so now what the courts are doing, the sins that they accuse a lot of a lot of the families now and parents going through it now is, oh, well, you two are in disagreement, so we're going to punish you for that. So they look for anything and everything.
And the bottom line is, whether you're in disagreement or not, whether the state agrees with your divorce or not, whether they want to punish divorce or not, they cannot deprive your child of equal rights to both parents based on one of you choosing to get divorced or based on both of you choosing to get divorced. They cannot punish the child for what you as adults do.
And that brings us to our parental equality slide. There are a bunch of recent studies out there, and one of them is the Journal of Epidemiology and Community Health that found that children are mentally healthiest when they can split their time between both divorced parents. So if you want some of the studies and shared parenting facts, you can get some of these off the slides. Like I said, I'm going to email the slide PDF to all of you, so you will have this. You don't have to write it down as quickly as possible or anything like that. You're going to get a copy of this right after this presentation. Typos and all if you find any. So, but this is, again, this was from the Cordell and Cordell on the MPO site. We also have some information about studies and our argument around it on our blog site, because you do want to be a little bit careful. You don't want to rely on studies. You can just use them to help show that this is healthy and that these studies are finding this, but you don't want to rely on the studies for your rights. So Just be aware of that. You got to
you rely on the Constitution and what the Supreme Court has said about your rights and your child's rights. You use these studies to make the judge feel better about doing what he's supposed to do in the first place.
But just be aware, I mean, the other side, they can go dig up other studies on, you know, that counter it. So that's why we say be really cautious, because people do all kinds of different studies, and they sometimes use studies to manipulate courts. That's what the mental health professionals and psychologists are being used for notoriously in these family law cases, is to manipulate the court to the side of the parent that they're, whoever that psychologist or mental health professional might be choosing. I'm not saying that about every single one of them in that profession. I'm just saying that's become a common way that we've seen them get used in the process.
That's what the court battle is about in divorce and custody proceedings. It is not about the law. The judge in almost every state has nearly absolute authority to make whatever decision they want. And when a judge or anybody has that kind of authority, it's no longer about the law. It is about appealing to that individual's emotional biases, getting them to become in your favor and to be against the other person.
Yeah.
And they use emotional manipulation, psychological manipulation, every kind of manipulation they can, because the entire process is about manipulating the judge to give you what you want. And
you want to put the studies into perspective. Take a look at the last bullet point, children from single parent, or sorry, the second to last bullet point. Children of divorced parents fare significantly better when they spend parenting time with both parents. Children who regularly do this have fewer injuries, less asthma, less headaches, and less speech defects than children primarily raised by one parent. Now, if they're just doing that study in the context of divorce and there are two parents available, that's fine. But what if there aren't two parents available anymore? Then, you know, just be careful the studies have done this correctly, because a child raised by one parent alone, let's say the other parent doesn't want to be a part of that child's life. Now, are they saying that single parent is going to have a child that's going to have more headaches, you know, more asthma, more injuries just because the other parent isn't around? So just make sure you question yourself on that, because there are some single parents who didn't have a choice. But what I would say about something like that is that again, I would say if that's happening to children who do have two parents, but a parent's being restricted, that's court induced then, right? That's not those parents' fault. They're fighting this way because the court's allowing it, because they're refusing to protect your rights. So
not only is the court allowing it, the court is demanding it. They set up the battleground and bring you in and force you to battle.
Yeah. So my argument, or our argument, would be the courts are causing that. That's not caused by being raised by one parent. That's caused by them in creating a second-class parent and a second-class child. So, anyways. So now on to declaratory judgment, which is, these are the solutions for how you're going to prevent all of that stuff that we just went over. So Ron's going to explain to you what the declaratory judgment is.
Okay. So very quickly, for those of you who don't know, there are two legal systems in this country, two judicial systems. There's a federal judiciary and a state judiciary, and there are 50 different state judiciaries. You can file declaratory judgments in federal court and in state court. However, it's very difficult in federal court. And if you have an open case, if you're in a custody battle, it is almost impossible to be heard in the federal court. So don't waste your time on that unless you study this and you meet some very specific requirements. Almost every state, and I believe now every state, has a declaratory judgment statute. And what these statutes say, and then most of them mimic the federal statute, and what they say is that if you have a case in controversy, if you have some kind of issue going on that's before the courts or about to be before the courts, and you can ask the court to declare what your rights are, either under the Constitution, under state statutes, or even under private contracts.
In order to simplify
the process. If you can ask them to do this, and doing so will simplify the process or even resolve or eliminate the need for judicial proceedings, then you can file this declaratory judgment. And what we're saying is that we're asking the courts to declare what your federal constitutional rights are as a fit parent, regardless of your marital status, and more importantly, what your child's rights are with each parent and whether those rights are equal with each parent. So once you decide what those rights are, then we're asking the court to state what level of procedure is required.
Yeah, right? and here's what that does, is that simplifies the process, doesn't it? Because if the court decides you have these rights and they decide that there's a process required before they go in and affect those rights, guess what? What did you just do? You just cut out all those GALs, child custody studies, social studies, all of those, because the court just said those are fundamental rights. So once they establish that those are fundamental rights, then they decide what the process is, and we go into more details of that in another webinar. But the important thing is that once they do that, they have just cut off a bunch of things that you need to litigate about. So now you don't need to argue over whether or not you have equal rights. You do. Now the judge has to protect them. It's a completely different argument now, isn't it?
Right. And where this is powerful is it forces the judge to commit in writing to these things, right? And so they can't make a decision and then justify it any way they want to. You're asking them up front to declare and put in writing that we either have these fundamental rights or we don't. We either have specific procedural protections for these rights or we don't. And if they say you do, then the court means that the court has to do certain things in certain ways, or they are abusing their discretion. If they say you don't, then when it's time for appeal, you have something solid to appeal on, because the federal courts and the United States Supreme Court have very clearly said that you do have these rights. And then you have real solid appealable arguments, not just you ruled against me, I didn't like it.
So now we're going to move on to the motion. So now that you understand a little bit about the declaratory judgment and the reason it's important, these motions have set this up for you. So instead of having to file a federal brief like we did, what we did is simplified that into these two motions. They are, I'll just try to show these other two slides to you real quick. One is an equal protection motion.
So real quickly, both of these come from the 14th Amendment. What the 14th Amendment does for us, it gives us a couple of things. One is it has a due process clause, and that says that the state, and specifically the state, cannot deprive you of life, liberty, or property without due process of law. Now, these are called substantive rights. Your life, your liberty, your property are called substantive rights. That term liberty is a very big, poorly defined term, and it means a whole lot of things. The first thing it means is the first 9 amendments to the Constitution, your First Amendment right of free speech, freedom of religion, all of these things, your Second Amendment right to bear arms, your Fourth Amendment right to be free from seizure and searches. All of those are substantive rights that, as of the 14th Amendment, apply to the states, and those limit the states, right? So these substantive rights,
which are in the second motion,
right.
By the way. I mentioned one's the equal protection motion. He's also talking about the due process motion, which is substantive rights.
And so what these rights are saying that you have these rights and that they are a certain level of rights called fundamental. And when they are fundamental, it is incredibly hard for the states to deprive you of these rights. They have additional procedural burdens that they have to meet, and that's the due process part of it. Due process means there is a procedure that you have to go through, and the procedure is the same for everybody, and the state has to follow it. So the first motion, the substantive motion, tells us what those substantive rights are, right? And then the other motion is the equal protection right. The other clause that's important in the 14th Amendment is the clause that says no state shall deny any individual the equal protection of the laws. This means if you're similarly situated to someone else, the same law applies to you in the same way. Now, I mentioned earlier that they cannot infringe your rights based on your marital status. They can't punish the child because of the sins of the parent. And what that means is that they cannot classify you differently because you're single. They cannot classify you differently because you're getting divorced. And that means there is one class of parents, fit parents, that have fundamental rights. If you're an unfit parent, then they can deprive you of your rights. But a fit parent cannot be deprived of their rights except under some very, very strict conditions. And you as a divorced parent or you as a single parent are still in that class of fit parent, and they cannot separate you out because of your marital status. And so they must protect your rights the same as they would a married person's rights. And that means that there are certain due process procedures that apply both to your substantive rights and to your equal protection rights. So the first two motions establish that you have these substantive rights and these equal protection rights, and that they are fundamental. And because they are fundamental, the highest, most strict level of procedural protections applies. Right? And we go into in the motion specifically what that means. And real quickly, what that means is you don't have to prove anything. The state has to prove it. The state has to prove a compelling state interest. That means their choice to act has to be necessary. They can't just want to. They can't just say it's a good idea. It has to be necessary to protect whatever state interest they're putting out there. Their statutes have to be very precisely written so that they only limit the rights that are necessary and they don't limit any others. When the state statute says that they can deprive you of any right they want based on the best interest of the child, that is so far from being precisely drawn, it's not even funny. They are wildly unconstitutional. They do not meet that test. And lastly, and this is critically important, they have to use the least restrictive means possible when they correct an action or when they take an action. So when they write an order, that order has to be provide as little restriction on your rights as is possible and still achieve their legitimate interest. What they said was their compelling interest. And that means 50-50. They can't take 1 minute more away from you than the other parent unless they can prove that's the least effective, least restrictive way to accomplish what they want to accomplish. And that what they have to accomplish has to be compelling. So this is very, very powerful. And what we're doing in separating out the motions is separating out the issues into those two clear places, substantive rights, equal protection rights, and then saying that this level of procedure applies because of these rights. And that very powerfully blocks the judge, locks him into a very narrow channel of what he can or can't do.
Yeah, so if any of you saw the videos, again, they're on our YouTube channel. You'll get that in your email if you haven't. This equal protection video, we don't have time to play it tonight, but this one will, it gives you some ideas about how to argue for the court responding to your equal protection motion. And this one gives you a little bit of an idea of some of the things that you would argue to your attorney or the court for using the substantive rights motion. And I just wanted to mention something real quick regarding the declaratory judgment and why it's so important. To remember, these equal protection substantive rights that they have, you're basically presenting the declaratory judgment relief to the courts in these two motions, as opposed to a brief. You're starting with these motions, okay? And the declaratory judgment, it's so important because what it is it's a way for parents to overcome the courts ignoring them when they have gone to court and said, hey, I have constitutional rights, and the judges are like, shut up, don't say it again, I don't want to hear it again. Well, they didn't have a way. Parents then didn't know, how can I force this court to respond to this claim that I'm making? This is how. You would use these motions, and you would learn how to argue these motions. We have some separate webinars that you can take for these motions where we walk you through a more structured argument so that you know how to actually present the motions and make the arguments yourself. It's important you know the arguments yourself so you can teach them to an attorney if you have one, or if you need to use them yourself.
And in addition to the motions, with the equal protection motion right now, there is a paper that we've written that explains the arguments, that cites all of the Supreme Court and federal appellate court cases that apply, and provides all the legal backing for that, proves to the judge that what we're saying in the motion is legitimate and is the law that they must follow.
And that's with the equal protection motion.
And what they do, again, is so you have to argue orally, but you don't have to be perfect arguing orally, because you will file these with the brief in support of the brief, or with the motions in support of the motions, and they will give all of the details to the judge.
Right. And if you want links to the webinars on the on learning how to go through the logical process to use these motions, the equal protection substantive rights, you will get that in your email. Later, when this webinar link is up, then I'll try to put hot links on it. But it's very important for all of you to understand, because we did get a comment already on one of the videos, which is great. It's great to know what people are thinking. But it was a comment stating, "Oh, great! I'm going to use that Article 6 argument with my court." And the thing about it is, okay, that's great. These do empower you. However, if you do not know how to logically argue through these, they will find ways to twist out of it. So if you only know one piece here and one piece there, and you've got these big gaps with knowing how to logically step through this process, they're going to step you right out of it, because they're going to push you right back into their abusive process, their broad discretion and taking over the rights, because you don't know how to argue through that in a way that persuades the judge. You want to be able to persuade the judge so you can try to avoid appeal. So if you don't know all the entire process for this, you're going to find yourself in an appeal, and you're going to say, darn it, I thought if I said this, then it would be over.
Right. But one of the ways you avoid the appeal is by making it very clear to the judge that you know exactly what you're talking about. You file both in writing and oral argument the right constitutional arguments, and you make it clear to the judge, if you abuse your discretion, you will be appealed, and I am setting this up for appeal so that you will be overturned.
And another,
this is an very important place for us to insert, especially for those attorneys who may be watching and listening. We are not attorneys. We do not claim to be attorneys, and we are not telling you specifically what to file as a legal document. Even though we're calling these things motions, they are training materials. They're written in the style and form of a motion. They do not have any of the legal headers or specifics that are required for your state, because, as I said, there are 50 different states, and each one is slightly different on the procedure and how you have to file motions and how you have to style them and all these things. We are not up to date on all 50 of those states. So you need to talk to your attorney about how to file these. And that's what the video walks you through, how to have the conversation with your attorney. If you are pro se, it's your absolute responsibility to understand what the laws are in your state, what the formatting requirements are for your motions, what can be presented and what can't, and what all the local rules are. So we're not telling you what those are. We're telling you what the Constitution says, what the Supreme Court has said, and we are giving you example arguments and proper citations to support those arguments in your case. Again, we are not attorneys.
So some of the process that you might go through, and like you said, we don't have all the steps here. We're just giving you an overview. Some of the process is you would have to ask the court for a hearing if you want to argue these. And again, that's why you go to an attorney and you say, hey, I want to hire you because you have legal training on how to be heard on these motions, and they know the process. If they don't, they'll figure it out, or learn it. The procedural requirements of the court. I mean, some states require that you inform the attorney general, because anytime you're making any kind of arguments about your rights, or if they see this as a challenge on the statutes, which, by the way, we don't have any statutes in these that were directly challenging, but it is an indirect challenge on their authority. It's a direct challenge on their authority, indirect challenge like on their statutes that say they get to decide best interests and those types of things. Right.
And again, since there are 50 different states and countless statutes, and these statutes are really twisted in how they're structured to hide the evil that these courts are doing, we in these motions, we are not directly challenging any state statutes. So for instance, in Texas, where we're familiar with this, if you challenge a state statute in either state court or federal court, there is a requirement that you notify and serve the attorney general. So we've sought to avoid that at least in the rules in Texas and hopefully in the rules in most states, by not going to the point of challenging any specific statute, but by asking the judge to clarify what the rights are and what level of process the court has to follow, not what the state says, not what the legislature says, but what are the requirements and duties of the judge. What must that judge do? Because that judge is a constitutional actor that has certain duties. And one of those duties is that they must apply the proper procedural protections for the issues at stake in any proceeding, whether it's criminal, civil, or whatever, or equity. They still have to follow the proper procedure, and they have to do that as an affirmative duty. They can't say you didn't ask me to, or you didn't do this.
And they can't say the legislators get to decide that, because no, they're the judge. They decide what process applies to your fundamental rights, not the legislator. In their court, they decide what requirements they have before they can affect those rights.
So it's their duty to read what the Supreme Court and the federal courts and their state superior courts, their appellate courts have said about what process is necessary, and to apply that process. That's their duty as judges.
So what you're going to want to ask an attorney is what rules govern the procedures of the court for hearing these motions, so that he or she can then go and figure out, hey, he or she would present them to the court, and then the judge would say, okay, I want you to inform the AG, and I want you to do this. Now, that's not a denial of hearing those motions yet. That's simply the judge figuring out the process for hearing the motions. Because remember, the other side will object if the judge violates the process for hearing those motions, and you don't want to get kicked out on a technicality.
So for instance, we went through this in Texas, where the judge decided, and really just playing it very safe, decided that it was necessary to inform the Attorney General. We don't think it was under the law, but the judge thought it was. And so that's playing it safe. He said, okay, you're going to have to serve the Attorney General and give them time to show up. And there were rules how the Attorney General is to be served and how much time they have to respond. Once that passes and they either show up and defend their statutes or they don't have to show up, but then we can proceed.
So parents and attorneys, they are filing these arguments. So how they might manipulate the intent of the motions into something that they're not is exactly what he just covered by saying, oh, these are challenging the statutes. Well, it's not challenging the statute unless you list one out and you challenge that statute directly. But either way, if the judge wants to follow a particular process or procedure for hearing the motions, don't get too stressed out about that. Again, it's not a denial. Just follow that process and then get in there and be heard on these motions prior to any other trials or any other hearings, because you are challenging their jurisdiction to hear those things, and they need to address your declaratory relief that you asked for. So this is prior to. You do not say, okay, I'm going to let you hear these after that. That doesn't work. You got to be heard before any other hearings or trials.
Because these set the rules for how any other proceeding, any other hearing is going to be conducted.
We've just got a couple more slides to go. This next one is on the objections that you're going to face. And if any of you saw the video, that one actually gives you the wording of the abuse of discretion oral objection and the lack of jurisdiction oral objection, the way that we actually give it to some of the parents that are taking our testimony support group. We do have a support group, by the way. If any of you don't know about that, I will add that to the email. That is a support group that helps you learn how to testify in a way that is more effective. It's not about lying or making things up or manipulating, but it's about telling your story, getting the truth out there in the most effective way, and at the same time testifying in a way that reflects that your rights, that you're asserting your rights, that your rights are protecting you. So there's a technique to that, and we walk you through it in these support groups. So if you want to get into that, you'll find a link on your email as well.
So objecting is very, very important if you plan to appeal, and we're setting all this stuff up so that you have an incredibly strong appeal if the judge does the wrong thing. So it's always important to object where proper, and you always have the right to object. Right? So And there are two ways to object. Attorneys almost always object orally, and that's it. But you can object in writing. I personally filed written objections in my case, even after the hearings, although that's technically was an issue, but I still did it because I wanted things on the record, and because we're preparing a record for appeal for the appellate court to read and see all of these things. We're starting to provide written objections for certain things. And so the first objection deals with lack of jurisdiction and abuse of discretion. We challenge jurisdiction because they cannot move forward. Any challenge to jurisdiction essentially stops everything, and they have to address their proper jurisdiction before they can move forward. That one's a little bit iffy, but we have some strong arguments for it, but it's a little bit iffy.
To give you a quick example of what it is, if you didn't see the video, it goes something like this. In relation to fundamental rights, this court has lack of jurisdiction because it has not determined on the record what rights are in question here today, and has not proven a compelling state interest authorizing this court to interfere, reduce, or unduly burden fundamental rights, the care, custody, and control of my child and my earnings. So it goes something like that. I will put it on your emails for you, but I just wanted to give you an idea.
And the use of this is if they refuse to give you a hearing on these motions, or they don't rule on these motions properly, then you would raise this objection. You would say, I have a motion to object. I'd like to file it in writing, and I'd like to raise an oral objection at this point. And you put it in the record. And again, the reason it's in writing is because the appeals court, if you wind up in appeal, will read everything that's in the record. And that's why you want it written down. You don't want to depend on transcripts. You want it written down your way with your citations, right? So put the two together and object if they don't do the proper thing here. And we'll be working on other objections over time for different things. For instance, a lot of places like to say the best interest of the child is a compelling state interest, and nothing could be further from the truth. The Supreme Court has essentially said it is not. And so we're going to have objections for that as well, and other things that are common for these courts to try to weasel their way out of doing what they're supposed to do.
And the abuse of discretion objection is really short, so I want to tell you guys what it is. But again, I'll paste it on your email along with the video.
It's essentially the same argument.
Yeah, but it's really short. It's objection, abuse of discretion. This court has failed to apply proper procedural, constitutionally adequate protections.
And the written motion goes into a lot more detail about what those are and what is required of the court and what the basis of it is. So it's more than just what she's reading out. She's reading out the top lines from it.
Just what you would say orally to the court, and then you say, I want to file a written objection as well. So again, that's why it's important that if you want to know more about how to walk through the logic of these motions, you're going to want to get into those webinars walking you through it. Those 2 webinars are paid webinars. They're not very much, but they are paid because we had to put a lot of work into those to structure and walk you through the logic. It's a very educational. And
the words we use are key words, by the way. We didn't just pull out abuse of discretion out of thin air. The way appellate courts operate, most appellate court cases deal with whether or not the judge abused their discretion. So when you use this language, you're sending the signal to the appellate court, and you're sending the signal to the trial court that you know exactly what you're talking about, and you know exactly how you're going to challenge their decisions on appeal. And that will compel them in many cases to do the right thing so that you never have to go to appeal.
And that concludes the slide presentation. So let me go back to our webinar here and see if all of you guys are still here and awake and have any questions. So hopefully we didn't put anyone to sleep. So if any, I'm going to just grab a couple quick questions because we are at the 1 hour. So if any of you need to go, you have work early in the morning, go ahead and go. You'll get this link. You'll get a couple of these questions. If you have additional questions, email them over to us. So at our contact tab, I typed it to you earlier, but I'll put it here as well. I'll put it here again. Contact us. The reason we have you go there rather than just sending it straight to an email is because everyone who's contacted us, I like to try to take it in order unless I see one that's an emergency, like a hearing coming up tomorrow. I like to take them in as close to the order as I can so that everyone gets treated fairly and so that I don't miss somebody's question.
Right. And so that's how we manage contacts with people. But another thing it does that's vitally important is that it protects us. In order to submit that contact request, you have to click a box that acknowledges that where you acknowledge that you recognize we are not attorneys. And we can't stress that because attorneys do not want you to have this information. Judges do not want you to have this information. They want to protect their turf. They want to protect their little racket of family court because it's $40 billion a year that they're stealing from all of us. And so they're going to do everything they can to stop this. And you have to acknowledge that we're not attorneys. We're only providing educational materials.
I have another webinar tomorrow. It is on parental alienation for parents being alienated. You might want to get in that one tomorrow night. That is free as well. Thanks for all coming, and I hope you have a good night. I hope you rest better, and we look forward to you all being empowered. Good night.
Good night.